cultures, and beliefs. It reminds us that, the International Human Rights Day also calls for a collective action, advocacy, and education, values that we as a Faculty of Law hold dearly. It emphasizes the need for unwavering commitment to safeguarding the fundamental rights enshrined in international treaties and national constitutions. Yet, these rights cannot be taken for granted. They must be actively defended and reinforced and expanded through continuous learning, policy development, and legal practice. Universities, such as International Balkan University, are not only places where knowledge is shared, but also where the foundations of justice, fairness, and equalities are built. They are spaces where future leaders, policymakers, and advocates are equipped with the intellectual tools and moral compass necessary to champion human rights in an ever-changing world. Today's event, organized by our legal clinic at the International Balkan University, reflects our shared commitment to advancing human rights through dialogue, research, and advocacy. We believe that legal education extends far beyond the classroom. It connects theoretical learning with real-world engagement, empowering students to address legal challenges and promote justice for all. We are privileged to have a distinguished panel of experts, and we have a pleasure of them being part of our staff, joining us today, whose wealth of knowledge and experience will guide us through some of the most pressing human rights issues of our time. Their insight will deepen our understanding, spark meaningful discussion, and I hope inspire each one of you to contribute to the promotion of human rights in our own unique ways. How the agenda will go today is that, firstly, the opening remarks of this event will be given by our dear and irreplaceable Dean of the Faculty of Law, Professor Dr. Nikola Dacev. And after that, what will follow is our first speaker will be Professor Dr. Natalia Shikova, and she will present on the extrajudicial protection of human rights. Our second speaker, Assistant Professor Dr. Marta Veseli, will address digitalization and human rights in the public sector. And finally, we will hear from Assistant Professor Dr. Ebru Ibish on the importance of the European Convention on the exercise of children's rights in protecting children's rights as human rights. Following the presentations, we will open the floor for a Q&A session, and please feel free during that session to engage with our speakers and share your questions and perspectives. Without further ado, it is my pleasure to invite Professor Dr. Nikola Dacev, the Dean of Faculty of Law at International Balkan University, to deliver the official opening address. Thank you.
Thank you, Alexandra. Dear colleagues, dear professors, dear students, dear guests, I'm really happy to welcome you all on this occasion to mark the International Human Rights Day. First of all, I would like to say that this is, as an event at the Faculty of Law, I think that it has the longest tradition, and it was initiated by the previous Dean of the Faculty of Law, Professor Natalia, way back in maybe 2017, correct me if I'm mistaken. So we have organized various events for the Human Rights Day. And all of the academic staff contributed a lot throughout these years. Events related to guest lectures, panel discussions, workshops, competitions for the students, etc. So I can mention just a few of them. Of course, we had maybe for a year or two interruption because of the pandemic, but every year we try to organize one interesting event for the students, and I think that we have done a great job till now. For example, I can mention that a lot of eminent experts in the field have conducted lectures. For example, the former president of the Republic of North Macedonia also had a lecture a couple of years ago. Last year, for example, we had former ambassadors, Macedonian ambassadors, that had a panel discussion. and many more, many more. This year, I have to say that we have decided to have more than one event. It's not just one day, to mark the human rights. Basically, this is the month that will be month of December that will be dedicated to the human rights. What motivates us is that the human rights are emerging, are changing, evolving. Of course, a lot has been done, a lot of regulations that have been enacted, but of course, the protection of some human rights is still lacking. I can mention just some of them, let's say the racial discrimination, the rights of the refugees, of the migrants, the freedom of expression, and so on. My colleagues will speak more about it, of course. Of course, with the changes in this area, in this field, and the laws should also follow these changes, and that's why this is an additional motivation every year to organize, as I have said now, for example, more than one event. I can mention, for example, how we started last Friday with thanks to the legal clinic and Professor Ebru, who coordinates the legal clinic. We have organized an event, a lecture for the high schoolers from high school Shaib Yusuf from Shuto Rizari, where they have been able to learn more about the rights they have. The children's rights are very important, special rights that are, for example, I can mention some of them: right to education, right to healthcare, right to be protected from violence, even the right to rest, right to play games, etc. So the students from this high school were able to learn more about their rights and the protection of these rights. Now we continue, of course. Today we have one great panel. I think for the first time for the Human Rights Day we have panelists from the Faculty of Law, from IBU, which is I'm so proud because of that, because we also have a lot of things to say. Of course, my colleagues, Professor Natalia, Professor Marta, and Professor Ebru, from their perspectives, will speak about the human rights. And of course, I encourage you to join actively, to ask questions, and because this event is for our students, of course. Thank you for listening, and I wish you to have a great panel.
Now it is my pleasure to invite the first speaker, our dear Professor Dr. Natalia Shikova.
Thank you very much. It is a great pleasure to be here. First of all, my apologies. I don't feel very well today, but I'll do my best to give you an overview of my presentation and what I was speaking about, the human rights. Since we celebrate all week and we have many aspects of the human rights protection, mine will be protection outside of the court bodies. So it is possible in a democratic society through certain institutions to protect and enhance human rights. So is it the court system only necessary through the justice, or we can engage more in establishing more democratic institutions that will actually enforce the human rights? And the things that I will speak about is an actual research that I was doing in the previous 6 months, and speaks about the ombudsman as a protector of the human rights in the country. It's a part of the enhancement of the governments and public administration reforms. It's a special funds that should support democratic processes in the country. So the main idea here is to increase professional standards in working, and the way to improve institutional accountability from one side, and from the other side, to encourage citizens to ask more from the ones who are making decisions or the ones who are here to protect the human rights. So basically to give us a tool how we as a citizens should keep the ones who are bringing decisions accountable for what they are doing. So basically this speaks about the work of the Ombudsman and a response to the citizen request, but as well from the other side, the administrations and the services they provide to the citizen. So what is the behind this institution? So basically, should protect all the constitutional and legal rights of citizens and all the persons, not all the citizens, that are violated by the acts and actions or missions of the state bodies and organizations that they have a public responsibility. So in each case, to act whenever we have a situation like that. How is Ombudsman is established? In different countries, in all of the countries, is basically we have a special law for the Ombudsman, and as well in many countries, as in our country, is constitutionally set, and basically speaks about they have a constitutional amendments, and a law for the Ombudsman that actually regulates the scope of the work of the Ombudsman. So the powers of the Ombudsman do not apply to the private sector, but basically only to the public sector institutions or the one they have a public authorities. And it's not a legislative, it's not an executive, and not is a judicial power. It's not a prosecution body. It's something different. It's a system of control, of a democratic control in a country, and intervenes with proposals, suggestions, etc. So it doesn't bring decisions that are mandatory, but basically supports the whole system. So this is the essence of it, is to promote the human rights and to protect the human rights within this system. The Ombudsman works within certain principles that are set within the law. Should be independent, should be impartial, should not be connected with any political party, with any type of affiliation, should be objective in its working. In North Macedonia, we have another responsibility of the Ombudsman, and that is following the equitable representation of the communities into the public administration. So this is the special, let's say, task of the Ombudsman. So in this setup, the Ombudsman promotes the good governance. It increases the citizen trust in our public institutions because we know that we have someone behind who will support our rights. And the duties are different from one country to another country. However, this is our oldest institution, let's say, established in the 18th century, first of course in the Scandinavian countries. Later on, all the countries that are part of this former communist bloc as well accepted and established this type of the institution. However, despite there is a variety of laws for regulating the Ombudsman, there is a regional initiatives and regional standards what are expected from the institutions to be set up on the place. So when the Ombudsman intervenes, we have acts and activities of administrative bodies within the public sector violates the rights of the citizen, when the responsible persons in the administration incorrectly adopt administrative law or applied the laws, when we have a violation of the administrative procedure, when we have arbitrary actions from the public institution, and we have any kind of discrimination. Ombudsman each of the year produces certain reports that are annual reports, which are public and transparent. And as I told you, they don't have they have a political, they have ethical and moral value in society. So basically, we should discuss about the Ombudsman reports. Unfortunately, in our country, the Ombudsman generates reports in total. So in the reports, we cannot see the special types of omission of the administration. So we cannot see in how many times the administration did not act on a proper way, did not act at all, did not discriminate, etc. So it's a general reports, and in the reports they're mainly focusing, unfortunately, on the position of a special vulnerable categories of the people, so they are not divided. In the other countries, you can see a separate report for the public administration, then you have a separate report for the prisoners, for the children, etc. Where, for example, you can see the area that is on your interest. This is my original research, and how we have the reports, they are narrative, and then you have a spreadsheets, and there are data there. And you will see here, this is by the years. Approximately, we have around 3,000 complaints of the citizens. So this is the, let's say, standard way of the complaints. The citizen complain to the ombudsman where their rights are violated. Not citizens, all the others who are living in the country. So when you divide, the most of them are in judiciary, in labor relationship, children rights, penal institutions. In judiciary is basically, because it's not a judicial body, it's not part of the system, it's for the not acting of the judiciary institution, or basically they are not starting the procedure in many other aspects. So most of these are the sectors that are most problematic. In this here we have the biggest complaints by the citizen. The ombudsman tries to resolve the cases by suggestions, etc. And we have around 15% of the cases, they are translated from they are changed from one year to another. They are moved because they are not resolved in these actual years. And this is however, besides by the complaints, the ombudsman should initiate by the institution's own acting when there is alleged violation of the human rights by the so that is only in the 15% of the cases. So ombudsman initiate by own initiative only in 15%. All the others are the complaints by the citizen. When we speak about how many the responsibility of the institutions, that is in 20%. What does it mean? It means that the ombudsman creates a report, sends the suggestions, and institutions are reacting only in the 20% of the cases. So it should be several times acting, several times sending reports, several times calling of the responsibility until the institutions react. And they are not only reacting when there is a particular violation of the right, but as well when we have a systematic violation of the right with a certain law, with even the ombudsman can initiate a constitutional, in front of the constitutional court, that it happens only in several times. So when we see how about these ombudsman reports, we can see these institutions face challenges. So it's not only important to have an institution, but as well as important how the institution effective is. So since all over the country already have institutions, we need to know what is the effectiveness of this institution and how we can improve it. First of all, the reports should be divided to the special group of that they address. And from the other hand, we have another constraint in the working of the ombudsman, and that is that the institution does not enjoy independence. It should be independent, and there is a special provision which is called Paris provision, in which those provisions, the institution should be financially and functionally independent. In our case, the institution is directly dependent from the Ministry of Finance, as well as in when the equipping of the body. Let's say it has an ombudsman and it has a deputy ombudsman, and 6 or 7 which are not filled, they are not voted in the parliament. So institution is not independent. In the European islands, has the status of the status B, and A is reserved for the ones that are independent. There will be a new law. Apparently, you will gain independence in some way of time. From the institutions' point of view, unlikely the institutions, I'm afraid they will say that, they don't take the ombudsman report so seriously. When we have a report by the government should discuss on a government session about the findings. That's number one. Second, the ombudsman reports are in the parliament in the last day, when the parliament session of the year, where there is no measure upon the findings, whatever I said previously, and basically you cannot keep the track of the acting of the institution, will they act about the ombudsman suggestions or not. So if we have no measures, then we have no way for monitoring. Now, how we can improve that? First of all, if we change the law, we always change the law, but it doesn't necessarily mean that we will change the structure, the system itself. The ombudsman should get more visibility, should get more, in fact, effectual power, and the institution should be strengthened. Now, how you can see how the institution can be strengthened when it doesn't have the measures that are mandatory for forming an alliances with the NGO sector, with the media, etc., whoever they are acting here in this process of the protection of the human rights. And here, additionally, is very much important to have informed and educated citizen that we know that we have some protection to ask more and to basically try to be responsible for realization of their own rights. On that way, for example, we can improve the functioning of the other institutions that are protecting the human rights. I will stop with my presentation here. There you will have a link of the research where you can see the data, you can see the actual finding, the position of the institution in the system, and here you can see one educative video, which is for a student. So thank you very much. I'll address your questions later if you have.
Now it is my pleasure to invite the second speaker for today, our distinguished professor, Assistant Professor Dr. Marta Veseli.
Thank you very much, Alexandra. Dear colleagues, dear students, it's an honor for me to be here in this great panel to discuss today a topic which lies exactly in between the law, technology, and governance. And the name is Digitalization and Human Rights in the Public Sector. I don't have a presentation, so you will have to hear me. Digitalization has swept through our public institutions with speed. This reshaping how governments interact with citizens, deliver services, and safeguard rights. So, as a legal scholar, I must say, I must acknowledge this dual-edged nature of the digitalization. So, on the one hand, digitalization holds remarkable promise for advancing human rights. That's the one side. And the other side is that it presents significant risks that require our vigilance and legal ingenuity. So, in the following, I will just shortly elaborate the opportunities and the challenges of the digitalization and how is the impact to the human rights. So first, let us consider the opportunities. Digital technologies have the potential to enhance accessibility to public services in ways previously unimaginable. Imagine you are living in a world where, for instance, healthcare is just a click away. A patient in a rural area or in a remote village uses a governmental health app. It enters the symptoms in the application, and it receives a diagnosis via an artificial intelligence generated system and schedules a teleconsultation immediately. All of this without having to leave their home. So that's reality. Transparency and accountability are actually among the greatest promises for digital transformation. Blockchain technology, for instance, can track even public funds in real time, preventing corruption and enhancing public trust. However, we as lawyers, as law academicians, we must question ourselves, are these innovations uniformly accessible? First thing, and second thing, are they deployed with the necessary safeguards to prevent misuse? So here I'm landing in the risks chapter. The risks of digitalization to fundamental of human rights are as profound as its promises. For instance, the right to privacy, which is enshrined in Article 12 of the Universal Declaration for Human Rights. That's also a very important human right. And in our increasingly digital public sector where data collection and surveillance is almost normalized, this right has to be actually more actively defended. Consider algorithmic bias as well. Governments increasingly rely on artificial intelligence to allocate the public funds, but these algorithms can perpetuate or even worsen the existing inequalities. And there is an issue also concerning the digital exclusion. We must not forget the ones who don't have any access to a reliable internet or no internet at all, or digital literacy. So the digital divide is not just a technological gap, but it is a profound inequality that can entrench the existing social hierarchies. The good side of the story is that we do have a guidance. We do have a guidance. There is a guidance. There are a lot of frameworks which have been released. The OECD, you have heard of this non-NGO already, I suppose, has released, for instance, in 2014, the recommendation on digital government strategies, where it urged the governments to design digital tools that are open, participatory, non-discriminatory, and which are prioritizing the human rights. Then we have, in 2020, the OECD policy framework on digital transformation. And there is entrenched the human-centric blueprint for aligning digital strategies with fundamental rights. These frameworks underscore a critical point. National strategies must integrate human rights from the outset and not as an afterthought. Some nations, some states are already leading in digitalization in the public sector. As an example, I can mention Estonia, the e-government model of Estonia is actually a case study in balancing innovation and protecting the human rights in a very good way. Second example, which can serve also as model for the governments, is the Germany's Data Ethics Commission report of 2019, provides also an ethical framework how the artificial intelligence can be deployed without violating human rights. And we as academics, we must position ourselves both mostly as architects and watchdogs of the digital transformation by doing research, combining law, technology, and so on. And our role extends beyond research to advocacy, actually equipping the next generations with tools to navigate this intersection responsibly. So in closing, as a conclusion remark, let me remind you that digitalization, just like the law, is a tool. And the tool can be used for good, namely in our case to advance the justice, or to perpetuate inequality, depending how we use it. And as lawyers, academics, and policymakers, we share the responsibility of ensuring the digital transformation to become a force for good. Thank you.
Now for our last speaker, it is my honor to invite the main organizer of this event, Professor Dr. Ebru İbiş.
Thank you so much, Alexandra. Yeah. Okay, so dear colleagues and dear students, first of all, I must mention that I'm very happy for seeing such a number of students interested for this event. And as our dean mentioned at the beginning, this year we're not organizing only a Human Rights Day, but we are organizing a Human Rights Month, which is very important for us as a law faculty. We started last week with rights of the vulnerable groups, where we had the perfect presentations prepared by our teaching assistants, Assistant Alexandra Ilievska and Assistant Seher Mustafa. Today we will continue with 3 different presentations from the different perspective of human rights. Next week we will have again one more event with artificial intelligence and human rights. Probably it will be in collaboration with Inox. And the last week from December we will close the Human Rights Month with constitutional rights. Today, I will focus mostly on protection of the rights of the child. I will mention several important conventions from United Nations, from European Union, our domestic laws, the situation of a juvenile justice system globally, and of course, I'm going to share some important data about the situation of violation of the rights of a child. Especially I decided because today we are facing a huge genocide, we are facing huge crimes against humanity, we are facing a huge crime of aggression and war crimes, and that's why I wanted to focus my presentation mostly on children which are living in conflict zones and children who are living in war zones. If I had to mention the concepts of today's presentation, as I told, especially I am going to emphasize the importance of European Convention on the Exercise of Children's Rights, the structure of the European Convention, and one more very important thing, because in the same time, the substantive law and the procedural law, and especially maybe we had to mention the violations from the procedural law. Of course, that it's not a coincidence that today we have a special juvenile or child justice system. We have a special courts for children. We have a special laws on children. And at the end of the day, we have the most known and the Convention on the Rights of the Child of the United Nations, which is one of the most ratified and signed convention in the world. Human rights are the foundation of freedom, peace, and justice. As we can see here, we have three very important elements: the freedom, the justice, and the peace, where, of course, we are going to mention the importance of these three very important fundamental rights, which are, of course, part of the Universal Declaration of the Human Rights, European Convention of the Human Rights, and such an important conventions who are dedicated to protect the rights, the human rights. Injustice everywhere is a threat to justice everywhere is one of my favorite quotes from Martin Luther King, which is totally, I would say, very important quote, because today, I mean, again, I'm going to mention the situation, especially between Israel and Palestine, because this is one of the proof where if we have an injustice somewhere, this will be the injustice everywhere. Human rights in general is a huge concept. Here we have a right of work, right of education, right to life, which is one of the most important fundamental rights, right of freedom of association, equal before the law, the right to trial, the right to family, right to marriage, right to work, which every right is. I am going to mention again the importance here, the European Convention of the Human Rights, and it's the part in general of the human rights. Why the human rights are important? As I already mentioned, we have different perspectives and different freedoms, which we already mentioned, but here I would like to focus on a concept of, or I would say the contemporary concept of the human rights, and just to show you or to locate the place of the rights of the child. First, I would like to start the rights of vulnerable groups as a part of the human rights, the women's rights, and the children's rights, which is today's topic. Especially when we are talking about the children's rights, I would like to emphasize several very important things. Why all the time when we are talking about the human rights, we have one more as an extra category, the protection of women and children. Again, this is not a coincidence, because mostly as victims of a very serious crimes such as the transnational crimes, the organized crimes, mostly the victim of, especially, I would say, the sexual offenders are children or women as vulnerable groups as well. If we take a look to the evolution of the rights of children, I would like to just shortly mention some main points about the evolution, just to catch the importance of the contemporary or the modern, I would say, the modern group or the modern model of rights of the children. First, in the 20th century, we didn't even have a different perspective or different theories or different or special protection of the rights of the child. But it's very important that first regulation started with the Factory Act from UK, which is mostly connected with the labor rights. And after that, here we have a very important concept, which is the child psychology. And this is a very important characteristics, because especially when if we take a look to any law or any code which is focused on protection of the rights of the child, it's not only provisions, but the provisions are divided to the provisions which are protecting the rights of the child, and on the other hand, we have a children's welfare, which is very important and one of the main principles even of the United Nations Convention on the Rights of the Child. Which are the grave violations of the rights of the child? This is from the report of UNICEF. We have killing and injuring children. Then in the second place, we have the recruitment of the children in the armed forces. We have the abduction of children, attacks at schools, refusal for lack from humanitarian support, and as a last form, we have rape. What is the impact of conflict on children? Mostly, with today's conditions, and especially if we take a look to the reports from 2023 and 2024, first we have that more children are going hungry. Then we have a situation with victims on preventable diseases. More children are out of school, which is one of the main violations of the right of education. Then we have that more of the children are at risk of the sexual violence, and that's why I emphasize the special group of protection of the rights of the woman and children. And at the end, we have that the more children are trapped without access of humanitarian aid. How many girls are living in a conflict zones? This is especially very important because if we take a look to the last reports of UNICEF, we are going to see that especially UNICEF pays attention to victims, to girl victims of crimes, mostly of the sexual crimes. Especially, I would like to mention this part with the child marriage, because child marriage is a category which started being most unfortunately popular, especially for and mostly the victim of this category are the children under the age of 18, and mostly even children under the age of 15 years old. Today, the forced child marriages are declaring such as even the form of organized crime, and even the form of transnational organized crime. The evolution of the rights of the children, I would like to divide this part into two very important groups. The first one is the legal framework, and the second one about the protection of the fundamental rights are the International Conventions of United Nations, of European Union, and the Council of Europe. The domestic laws on protection of the rights of the children, or the domestic laws on the laws on the justice of a child, which is the international concept. As I mentioned, we have a provisions of protection of the rights of the child, and we have a provisions for children welfare, which is very important for children well-being and the best interest of children, which is the main principle of the UN Convention on the Rights of the Child. These are very important criminal codes, I would say, because for the first time we have a category, a special sentences for the children, which means that here the codes paid an attention about that this is a special category. And especially the Constitutio Criminalis Teresiana, we have the term discernamento in Latin, which means criminal liability. And this is a very important moment, especially about sentencing of children. 1924 is a very important year for us, because for the first time the League of Nations, or in today's condition the United Nations, for the first time came with a special convention on the protection of the rights of the child. And after that we had the second Geneva Convention, and then the UN Convention on the Protection of the Children's Rights. These are some of the important international conventions on protection of the rights of the child, which in the first place we have the Convention on the protection of the rights of the child, especially the optional protocols of the convention. The first one is for the forced recruiting children on the armed forces. The second one is with child pornography and child prostitution, because we have a huge and very serious violation from this part. And we have, especially, I would like to mention the importance with the procedural rights of children, because when we are talking about protecting the rights of the child, we don't have to, of course, forget the position of the convicted children, children who are perpetrators of the crime, and children who are offended. Because, of course, we need even more regulation for protection of the rights of the child, especially when within the criminal justice system, we even had the problems with the secondary victimization, which is a huge problem for the development of child. If we take a look to the concept of the European Convention of the Exercise of the Children's Rights, because this is the one. Some of the articles are very important for us. The aim of the convention is, of course, promoting the rights of the child, especially the best interests of children. This is one of the main principles which we can find in almost every convention. The Tokyo rules, the Beijing rules, the UN conventions, the EU conventions, etc. Right to be informed and to express his or her own views in the proceedings. Duty to act speedily, which is even more important for the juvenile justice system and the child justice system, and the mediation. I want to highlight this part, because the restorative justice and mediation as a part of the restorative justice is very important to improve and to protect the rights of the children. Today we have more than 200 models of restorative justice model, especially they are very, I would say we have a perfect practice and practical cases in United States of America, especially in Washington and in Boston. But by the way, at the same time, we had to emphasize the importance that while we are talking about the process of the restorative justice or the process of the mediation, here we had to pay attention, of course, not to emphasize the position of the perpetrator of the offender and the victim of the crime, but here the main aim is to have, of course, the natural staff between two parties. As for the end, before I'm finishing my speech, I would like to emphasize two very important things. The first one is, do we need more regulation for protection of the rights of the child? I would say yes, even if we have so many conventions and recommendations from this field, but we don't have enough regulations in our domestic laws, in Europe, I would say in general. And on the other side, we don't have enough conventions of protecting of the rights of the child who are witnesses of crime and who are victims of crime. Do we need more regulation? Definitely, we need more regulation to have even more stable juvenile justice system. Thank you so much for the attention.
Thank you, dear Dean, and to all of the professors for these very valuable topics. Now we will open the Q&A session. So please raise your hand when you have a question. Please address it to who you're asking it to, and ask it politely, and the professors will come here on the stage and answer your question. Yes, please.
Program, and we also firsthand saw that how technology was used, for example, in marriages, even in divorces, voting systems. How do you think this system of digitalization, when it comes to implementing it to the society, or as in administration or bureaucracy in law aspect? Thank you.
The last sentence, how do I expect? What is your question?
How would you think it would be implemented? How can...
Well, in Estonia, it's already implemented, right?
No, I mean in other countries, for example.
well, they have just to follow the Estonian model, no?
Yeah, fair enough. Thank you.
No, I'm not sure whether I follow if I understood the question. So if you, of course, each state has its own strategies, and still the public administration is not entirely digitalized in Macedonia. It's still the beginning, or they are even writing the national strategy at the moment. So, and each state, they have their own different politics, of course. But now, actually, your question is more technically. So it's actually more from the technical point of view rather than from political or any other point of view, I would say. Because it's actually basically your question is whether can the Estonian model be implemented, yes or no. So I would say if technical is possible, then yes.
Okay, second question if anyone wants to ask. You don't have to be shy. Nope. Okay.
Maybe our colleague that already asked Professor Marta for the digitalization part. I think our colleague is from Faculty of Psychology as well, or no?
Political science.
Okay, political sciences. I'm sorry. Yeah, I thought that from the Faculty of Psychology because she's all the time interested for the rights of the child. Okay, it's my mistake. Sorry. Any other questions?
Yeah, Professor Mare, please.
In your presentation, you mentioned the special concern surrounding child marriage as a human rights violation. What are some of the steps, other than legislative, which have already been done, not just Macedonia, but in most countries around Europe, but what are the steps to take in practice to eradicate child marriage? Because unfortunately, it still occurs.
Yes. We have a lack of constitution, the regulation, I would say, from this part. I'm sorry, maybe I had to take a microphone. We have a lack of regulations, I would say, in domestic laws and international conventions as well, because this appeared, as I said, the last year as a different category of a crime, especially where the victims are the vulnerable groups, as I said. Mostly, do we have now cases in the courts still? We don't have any decision on these types of crime, but as a transnational crime or as an organized crime, we can now, I would say from 2024, we can define the forced child marriages as a criminal act. How are the regulations were going to be, or how the United Nations or the European Union, is the European Union going to work as a special convention on the protection of the children who are a victim of a child marriages? Probably, definitely. I mentioned this, that we had a need because otherwise, of course, we would have a lack of protection of the victims, of the child who are the victims of this type of crimes. We have some data that mostly the first examples with violation of these rights we have from the South Sudan, we have from Iraq, and we had several from Ethiopia, I guess. These are some new, I would say, information that we had from the reports of UNICEF. Yeah.
I also have a question.
Yes.
For you. But it's more related to women instead of children. So I was in a visit in the European Court for Human Rights, and the question will be regarding your personal opinion.
Yeah.
Do you think that the institutions like that need to be a little bit stronger? Because I asked about a certain case that we had here in Macedonia about a woman whose during operation organs were taken out of her and the institutions basically failed her. And I asked if the European Court of Human Rights can take its own initiative if the national institutions have failed, but they said no, basically, that
Definitely.
they have to take the case to the European Court of Human Rights.
Yeah.
Do you think that there is something missing there that will allow for those big institutions to take care of cases that haven't been brought up to them have the need to take place in those cases?
Okay, the procedure, especially especially the application of the European Convention of the Human Rights, is very strict, because we know and plus here it totally we don't have I mean, it's not very important is the victim a woman or a man, because in this case we don't have any discrimination or discriminatory character which we can mention as a discriminatory thing in the whole case. But the situation is that if the parties were if they applied to the European Convention of the Human Rights, to the European Court, I'm sorry, to the Human Rights, it's very clear that the whole provisions from the European Convention of the Human Rights will be applied for the specific case. Yeah, yeah, you're welcome. Thank you.
Is there any other question? Yes, Anthony, and then the professor.
Thank you very much. First of all, I would like to thank three of the professors for their wonderful lectures. So my question goes to Professor Natalia Shikova, regarding of when you say about the challenges or the response of the institutions on the side of when the ombudsman prepares reports and the institutions are not responding. Do you think that also is also the mistake of the ombudsman when the ombudsman is not pushing more? Is there any kind of initiatives? Are there any, we can say, steps forward so that the institutions could function properly to respond to also the needs of the ombudsman? Thank you.
Thanks a lot. I think in the democratic society, everybody has a responsibility. That's my point in essence. So it's not only the ombudsman of the institutions, but as well the ombudsman as institution, as well the civil society, citizen, and the media. So all of them should be in some kind of, how can I say, all to work together to increase the protection of the human rights. The ombudsman, except initiating some issues, some cases, it should have an obligation to educate the public, to raise the public awareness itself. So the responsibility is as well to everybody, as well to the institution. We cannot say that ombudsman needs ombudsman to protect its own right. I mean, it should be joint action from all the segments of society. That's my point. Thank you. Yeah.
I don't need the microphone. In your analysis, it was about the ombudsman here in Macedonia, and that he doesn't have any, like, he can't apply the rules, he can't make you do anything. He's giving suggestions, basically, and that only 20% of the other sides are reacting after his instructions. Do you know what is the case with other countries?
Yes.
Are there countries where this percentage is bigger so that we can follow or
Sure.
take some examples and implement in our country some good?
Sure. The ombudsman has a political power. It is ethical power. So it's a very important as an institution. Basically, the institution don't want to be part of the ombudsman report. I mean, however it is, if you're leading a certain institution, you don't want to see that each of the year, the one who is violating the human rights is a Ministry of Interior and stuff like that. So are there positive, so the institutions are not reacting immediately. So ombudsman repeats the finding, the suggestions and reports, and after that we can see certain improvement. But the point is that those are not indicated, those are not monitored, and these you cannot use them when you asking something, because whatever you do in a society, it should be evidence-based. We can just say something, but we need to have a data behind. So that's the issue. So we can see an improvement after several years or after several indications, suggestions, etc. The institutions that are working the best in many countries are, of course, the Scandinavian, because they have a longest tradition. and then the ones who are joining certain autonomy in the reacting. So they're not so kind of, they're part of the system, but outside of the system. Here, everything is mixed, and that's how the situation is. It can improve in some point of time, but with the joint forces. And additionally, the Ombudsman institutions that are specialized. You have Ombudsman for children, or in UK, you have Ombudsman for parking places. So whenever your right is violated while you park your car, and then you're subject to fines, but you think that you don't deserve it, we have a special Ombudsman for that. You have for army, for police, for different sectors. So there are many positive examples. But having the legal framework, I don't think it's enough. So it's basically the society needs to be educated in a democratic manner in institutions, the people who are working there, everybody. Thank you for your question.
Now, if there are no more questions, I would like to invite the Dean of Faculty of Law, Professor Dr. Nicola Datsev, to give the certificates to the speakers today. So, dear Professor Dr. Ebru Ibish, please come. And now for Assistant Professor Dr. Marta Veseli. And now for Associate Professor Dr. Natalia Shikova. And lastly, please remain there. Professor Ebru Ibish will give the certificate to you. Yeah. And one last photo, if all of you can take a picture here. Yeah. Thank you. Thank you for your participation today. So, as you are probably already informed, we will now give a certificate for participation to the students. I will read the names fastly, so please come here to pick it up. Sorry if I'll butcher some of the names, I'll try my best. Fethiye Demir. Anthony, can you please come help me? Come. Extra. Nergis Kılcarslan. Anthony? Yes, thank you. Efsan Uçar. Semanur Isik. Yagmur Kirsanlioglu. Helin Ece Özcan.